Good afternoon. Can you all hear me? Oh, they can't. Just a nod if you can hear me on Zoom.
Megan, we can hear you. There's just a lot of background feed.
Okay, I apologize.
No
Everybody's
problem.
very cheery today. I have it. I'm just testing that you can still hear me. Yes, I'm getting a Nancy Tyler nod. Is that right? Or is that tea? Okay. Okay. Wasn't sure if you were sipping tea or nodding that you could hear me. Okay. We have a little bit of background still. I don't know why. Oh,
Megan, it does sound better now.
it does? Okay.
Yeah,
great.
less background too.
Okay. You're just missing all the joy and the cheer in the room. Don't worry.
I have that effect on people, Megan. Don't worry. I don't take it personal.
Okay, we're gonna get started in just a couple minutes. Folks are just settling in person, sitting down, so. Okay. All right, how's it going? Good. All right, is everybody settled in the room? You need a minute or two? Okay. All right. Just giving it one more minute for folks to join online as well. All right, I think we're ready. And I know we have a couple more people joining online, but in the interest of time, I am gonna call the meeting to order. And we'll start with the welcome and introduction of the council members. I'm gonna go around to the folks in the room first, and then we'll go to the folks on Zoom. So happy holidays. My name is Megan Scanlon. I'm the CEO at the Connecticut Coalition Against Domestic Violence, also the co-chair of this committee, and I'm gonna move to my left, Karen.
Karen Foley O'Connor, CEO of the Network Against Domestic Abuse.
Good afternoon, all. Alaric Fox on behalf of the Chiefs of Police Association. I'm the police chief in Enfield, Connecticut.
Good afternoon, Mark Pelka, Judicial Branch, Office of Victim Services.
Good afternoon, I'm Jody Tuno. I'm the Director of Family Services, part of Connecticut's Judicial Branch.
Good afternoon, Merritt LaJoy, Complaint Officer for the Office of the Victim Advocate.
Good afternoon, Nancy Turner, representing the Board of Pardons and Paroles.
Good afternoon, Johanna Canning on behalf of the Acting Chief Public Defender.
Sarah Stair, Senior Assistant State's Attorney, GA10 New London.
Good afternoon, Gail Hardy, designee for the Chief State's Attorney and co-chair of the Arrests, Warrants, and Orders of Protection Subcommittee.
Okay, going to folks on Zoom, I'm going to start with my co-chair, Senator Flexer.
Good afternoon. My name is May Flexer. I'm a state senator for the 29th district, and I am the co-chair of this council. Good to see everyone today.
Thank you. Representative Leeper.
Hey, Megan. Hey, everyone. Sorry, I'm in two meetings at once, so I'm doing my best, but happy to be
Totally
here.
fine. Totally fine. Welcome. Thank you. Captain Maynard.
Thank you.
Good afternoon, everyone. Captain Ryan Maynard, Connecticut State Police.
Great. Senator Kissel. Oh, you're on mute, Senator. Senator, you're on mute.
All righty, let's try it again. Hello, everyone. Happy afternoon. Happy holidays. Good afternoon. Merry Christmas. State Senator John Kissel, serving the people of North Central Connecticut in the 7th Senatorial District.
Great. Thank you. Okay. Phyllis.
Yes, good afternoon, everybody. Phyllis DeCara.
Welcome. Ginger.
Hi, I'm Ginger Wilk. I'm the Senior Director of Reentry Services for Family Reentry and CRJ.
Welcome. Andrea.
Good afternoon, everyone. Andrea O'Connor, Family Violence Victim Advocate Program Manager for the Umbrella Center for Domestic Violence Services. Please forgive my appearance. I am home with the flu.
Oh, no, just don't put yourself off camera. That's fine. The fact that you even joined is a big win. Okay, Judge Doyle.
That's a tough act to follow. Kevin Doyle, I'm a judge at Connecticut Superior Court. Thank you very much, everyone. Have a happy holiday.
Thank you, Judge. Danielle.
Good afternoon, Danielle Finquidolce, Judicial Branch Family Services.
Great. Shauna.
Hello, everyone. Shauna Harrington, Director of Legal Advocacy with CCADV.
Great. Nancy.
Good afternoon and happy holidays to everyone. Nancy Tyler, attorney and survivor representative on behalf of CCADV.
Great. Okay, let's see. I think I have Miss Garcia.
Good afternoon, everyone. Eulalia Garcia, designee for Commissioner Kuros with the Department of Correction.
Thanks. Welcome. Is there anybody that I missed? Just going through my boxes. Anybody I missed? Okay. All right. Great. Okay. So moving on the agenda would be the next item is just the approval of the October 1st meeting minutes. Do I have a motion to approve the meeting minutes?
I'll make a motion to approve.
Great. A second? Awesome. Well, who is the second? Sorry, I missed that. Okay, great. Thank you. Any discussion, edits, revisions to the minutes? Okay, hearing none, I'll move for a vote. All in favor of accepting the October 1st meeting minutes? Opposed?
Aye.
Any abstentions? Okay, great, awesome. Okay, next up are the subcommittee reports. I will turn it over to Chief Fox and Karen O'Connor for their subcommittee report update.
Thank you. The Law Enforcement Model Policy Subcommittee continues our focus on, in particular, the GPS monitoring piece that is embedded within the policy with an effort to provide improved clarity in this regard. There certainly are some, I guess I might describe them as aspirational ways to use the GPS program that may or may not be realistic, that may or may not be appropriate moving forward. But at a minimum, we do need to clean up some of the language within the policy that has fallen, if not out of compliance, at least somewhat out of date. We continue to work on that and are working on it as well today. Nothing beyond that. Thank you.
Great. Any questions or comments for Law Enforcement Model Policy Subcommittee?
Madam Chair?
Yes, Senator.
Yeah, just a question to my good Chief Fox from Enfield. So is this to be taken as there will be no recommendations for legislation this year promulgated out of your subcommittee?
At this point, I would say I do not believe flowing from this committee there will be any. I think that what we have at this point is a need to sync up what the program does and what the language describes it as. Certainly, there are places that we could take the GPS monitoring program, but I think that we need to do some legwork before we get to that point to decide whether or not there would be funding for that and whether or not some of the potential ideas, frankly, would pass constitutional muster.
Okay, through you, Madam Chair, thank you very much, Chief Fox. There may be an ask for through appropriations, but other than that, I hear you loud and clear, and thank you very much.
Thank you, Senator. Good to see you.
Likewise.
Thank you, Senator. Any other questions, comments? Okay, hearing none, I will move on to the next item. Arrest warrants and orders of protection.
Good afternoon once again. The Arrest Warrants and Orders of Protection Subcommittee met on November 19th to discuss and finalize the recommendations that this subcommittee would make for the report for the larger advisory council. We were able to meet with Darren Mitchell on November 17th, 2025. We were able to have representatives from law enforcement, including state and municipal police, prosecution, some members of the defense bar, family relations, victims advocate, and court operations to meet in person for a firearms seizure and compliance workshop. And again, that workshop was facilitated by Darren Mitchell, a fellow with the National Council of Juvenile and Family Court Judges. Mr. Mitchell presented virtually to this larger council earlier this year and has assisted other states in developing a firearm seizure program that ensures compliance by intimate partner violence offenders and establishes a protocol for police, courts, and prosecutors to hold offenders accountable when our IPV offenders fail to comply. We looked at the processes from the point of a 911 call coming into dispatch to police responding to a scene where firearms may be seized, interactions that officers may have with the victims at that scene, and we progress through the judicial court process where orders are entered, which may include a protective order and orders to surrender firearms or not to possess firearms. And all the while keeping the victim involved, addressing her safety concerns and ensuring compliance of the orders and how to handle non-compliance with orders through the judicial process. We discussed the challenges faced from the criminal perspective as well as the civil perspective. We engaged in sort of a SWOT exercise where we identify our successes, our challenges, our opportunities, SW. Threats. And we went through the entire process, conducting or engaging in a sort of mapping exercise where all of the entities who were represented could express their challenges. We came up with a number of challenges regarding compliance, investigation by law enforcement, and the challenges faced by the court with respect to the court having noticed that a defendant has either complied or has not complied. We also discussed the number of challenges that victims face, starting from the arraignment process right through to the disposition of a case. We discussed the law enforcement challenges that may exist, and Brianna Maurice, I'm sorry, discussed some of the issues that they face where our state of Connecticut lacks a mandatory registration of firearms, and where there's sometimes a gap where the police may go out to seize firearms. However, that information never gets back to the firearms registry regarding whether or not a defendant has relinquished all of his firearms in attempts to get him or her to do so. There are also confidentiality issues that are faced by the victims who may be inquiring whether or not a defendant has turned over all of his firearms because of the number of confidentiality constraints by the firearms registry. We looked at it from the civil perspective, where victims sometimes are going into court, they're unrepresented by counsel, and the lack of free or affordable attorneys for victims who are going through the civil process. And what Mr. Mitchell suggested that we do is probably to try to come up with 3 or 4 issues that we thought we could tackle. At an earlier point, we were considering establishing a pilot program. However, it may be time for us to regroup and try to establish or nail down what issues we'd like to tackle before going that route. We also noted that there may be some changes with respect to our judges, and we want to give judicial, as far as the judges are concerned, and all other required parties an opportunity to weigh in on how we would approach a pilot site going forward.
Thank you, Gail. Any questions, comments for the rest? Oh, sure. Attorney Canning.
Just a quick question. We discussed the possibility of getting some of his priorities, Darren's, I'm talking about Darren Mitchell's, his priorities from the list that we gather and maybe having him send that out to the council. Is that something we're still looking into, getting his insight, feedback?
Yes, we did receive a summary from him. I don't know if the other members of the subcommittee received that list. However, it is available, and I can make sure that the members of this group or council receives that copy.
Yeah, and I think Shauna was going to speak a little bit more in detail about the community mapping, and then we can certainly send it out. I know one of the recommendations in the report is to is to combine two of the groups. So I think we thought we would send it out in the new year, and then that would be under the newly formed court group was the idea. I don't know, Shauna, if you wanted to add more detail now since it came up.
No, thank you.
Okay. So we'll tackle the details in the new year.
And Madam Chair, there was another recommendation that this subcommittee had, and that was with respect to statutory language proposed for a victim who is seeking her address to remain confidential. And I believe Mr. DeTuno forwarded a copy of the language.
Yeah, it's the draft is in the report draft, which we'll get to. The language is in the report draft, which we'll get to later in the agenda.
That's all I have.
That's it. Okay, great. Any other questions, comments? Sorry, I'm also looking on Zoom. If I miss you, I apologize. Okay, all right. So moving on to offender standards.
That's weird.
All set?
All set. I think you're ready to rock and roll, yeah.
So the two things that Merritt, myself, and our subcommittee focused on recently is Merritt and I did a fairly deep dive into the outcomes and data from the Family Violence Education Program, and we were looking for trends and things that we might be able to bring forth to the committee. Really, I think that what we realized as we both went through that exercise is that for the most part the program is working as we expect it to, especially in terms of outcomes. What we're going to be doing next is looking at the 2024 data set to see if that was the same as the 23 data set. And we'll look at that to see if there's anything that we can bring forth to this body about how that program is operating from a statistical outcome focus. We also met with our colleagues from the Department of Correction, and one of the recommendations that our subcommittee was in charge of was to look at their domestic violence curriculum. That was forwarded to Merritt and myself, and we're in the process. I know Merritt has done more work on that than I have. She's gone through the curriculum, but Merritt and I, after the holidays, will sit down and look at that. We're also waiting, or we just recently received some of the data, the outcome data as well. I think we did receive it, and we're going to be reviewing that again with an eye toward potentially looking to have conversation with Department of Corrections about their programming and what their goals are for next year relative to that, but also just having a conversation about what they're doing there. It was very positive.
Great. And I apologize, Senator Kissel, you had a question, and I'm not sure if it was for the last subcommittee or this one, so I apologize.
It was
That.
no apology necessary. It was for State's Attorney Hardy, and it just seemed like within her presentation there was a legislative ask. But in your response to her, you said that there was going to be another part of the agenda where we would get to that. So that's sort of my parochial position: is what could I anticipate in this next legislative session? And I'm sure there'll be a wrap up at the end of our meeting today where all of those items will be delineated, so I know what's coming down the road.
Yes, and it's a good segue because this is my mistake. I think the subcommittee still has to vote on that language.
Yes.
Yes, so that was my error. The subcommittee still has to vote on the language.
For my understanding is that I gave that as draft, and that the legislative liaisons were going to help, finalize, because I know that Johanna had also received it, so I'm not sure what the feedback from her was on it. So
yeah,
I think
it went out in October.
But I think what we decided was that the recommendation was going to be that there's going to be statutory change, and then the actual cobbling of that language, is that going to be done at this level, or is that going to be with the legislative liaisons?
I think there's two steps to that. The first one is, sorry. Yep. 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 Yes, sorry, that's what I was talking about. But I think that went out several months ago. So I do think that could be voted on. I think it went out, from what I have in terms of emails and notes, it went out in October.
If I may, Megan, it did go out in October, but there were a couple of us who were left off the list, and it wasn't discovered until the day of the meeting in November that we actually hadn't received the language. For whatever reason, we were just bumped off the list. So we did get it, but we were unable to discuss it in the committee meeting because we had just received it within like hours before the meeting. So we hadn't had a chance to review, or certainly not with our legislative liaisons. So we did receive it in November, but the subcommittee has not had any actual discussion about it.
Okay.
My recollection.
I mean, can the subcommittee discuss it now?
Yeah, and my recollection is that we did vote on it, and you abstained because you said you didn't have an opportunity to review it. But we voted on it, and I believe it was determined that the larger council would have to vote on it at this meeting.
Yeah, it's in the draft report. So
As the person who provided it, I'm not looking to change it. It just is what it is. So, I mean, I just want to make sure that we have the right avenue of how this stuff is going to be dealt with. Is it going to be agreed upon at our level, or are the legislative liaisons going to look at it? It doesn't matter to me one way or the other. I just want to make sure that we figure that out.
Well, this is my understanding of when we talked about like things we wanted to see in this year of the council, was that we would, in these reports, have provided some sort of draft language, and then the next step would be getting those legislative liaisons together to take that draft language from the report and figure out what that final language is. That's my understanding. So I don't know, it sounds like from Gail, the subcommittee's voted on it, but maybe from Johanna's perspective, they haven't. Can we just have the subcommittee look at it now and vote, since we're in that subcommittee report section?
If I may, I don't have a problem discussing it and then voting. I just want to clarify, I objected to having the vote at all because I hadn't seen the language, and then I abstained because I hadn't seen the language.
Totally get it. But you've seen it now.
I've seen it now, so I'm available to discuss and vote.
Yeah, is everybody just comfortable to we're in that section of the agenda? Can we just get it done before 2025 is over? So,
Clock's a ticking.
does anybody have anything they want to change in the language? It's also in the draft report, if people want to check that out now too.
Megan,
and we're talking about the address. Yes. Yeah.
So this is just to clarify. This is on the draft report, page 10, paragraph labeled 2, add language to Connecticut General Statutes to allow use of a confidential address request form for victims in criminal court, correct? That's where we are right now?
Hold on, sorry, I'm just getting to the page for a second.
It's the last page.
Yes. Yep, item 2.
So I do have some concerns with this particular language. Probably the easier thing to tackle would be if this were to go through, I would like to see some language in there that is similar to, say, what Practice Book 40-10 says, which says that this is not applicable to defense counsel and his or her legal team. That is, keeping the information confidential should not be kept from counsel. Counsel should have access to that. And we do that in Practice Book 40-10. We do that regularly with police reports and other information that the state's attorney's office files hold, where defense counsel isn't allowed to hand it out, but they are allowed to review because we need it in order to properly defend our clients' rights. So that's the first thing, is that if we were going to do that, I would like to add that language. But the bigger issue that I have here, and this is a significant issue for my clients, is that I think we have a constitutional issue with the lack of notice here. What we're asking is to put at risk people's liberty for felony charges without giving them notice of exactly what it is they are to do. So essentially, we're saying you cannot go to this person's house, but we're not going to tell you where that person lives. You're going to have to guess. And if you guess wrong, if your doctor's office is next door or your kid's school is in the neighborhood, if you guess wrong, you're risking a felony conviction with not an insignificant amount of jail time. I think that has some constitutional due process issues attached to it. I think there's lack of notice in there. Quite often, you know, when there are these cases, quite often everybody knows where everybody lives because these are intimate relationships. But there are those cases where somebody has moved and the defendant is sort of in a position where they don't know where it is they are supposed to stay away from. So I think as written right now, and I don't know what the answer would be, but as written right now, I think this is a very big, this has a very big constitutional issue.
I'm sorry, I see Senator Flexer's hand up, or was up.
Thank you. I guess I'm asking initially for a clarification. What is the recommendation that was just made by the council member?
I guess my recommendation at this point would be to table this so that we could have a real discussion on it. We were unable to have a discussion as I didn't have the language on the last subcommittee date. And this, I think this is a very big issue that actually needs to be worked out. I don't know if there is an answer to it. There may be. There's lots of creative minds in this room that may be able to come up with a workaround. But I think it's premature right now, and I think we are going to run into some constitutional issues with that. So I would ask that we table it for now.
Okay.
You're going to submit a recommendation before a future meeting of this council to consider another version of this language, and what is the timeline for that?
I'm just pulling up the minutes from the subcommittee meeting. It looks like this was passed out in person. It actually wasn't electronic from what I'm reading. So did you not get a copy of the hard copy?
I did receive a copy of the hard copy
Yeah.
at the subcommittee meeting.
In October is the one.
In November.
Okay. All right. That's what.
It was October.
That's what the minutes are saying. So I'm just going off of what's recorded. I think maybe a compromise on this is to the language is in the report. I think the next step, Attorney Canning has always been to get the legislative liaisons together, and maybe that's the venue to sort of talk about adding some of the practice book language and maybe concerns around the constitutional due process in that meeting, because that's where I think we can get into more details with that. Would you be comfortable with that?
I think at this point I have to object to moving forward with a vote.
Okay. I'm just confused. It sounds like you did vote and you abstained, right? So the subcommittee, it sounds like, did vote on this language. I guess I'm just asking at this point, is the subcommittee recommending the language move forward in the draft report? That's what my understanding is based on the minutes. And I apologize I wasn't able to be there. I was in an event in Stamford. But so it sounds like the subcommittee overall moved the language forward to the report. I think once we get to the report, we can have a discussion. We're going to go over the report anyway. And we can talk about it there.
Madam
But it
Chair?
sounds like- Yes, Senator Kissel.
Yeah, I just want everyone. So part of this group was patterned after JJPOC. And so as a member of the legislature, it's important for us, both Republicans, Democrats, doesn't matter, that when we hear from these groups, such as this new group that was formulated by statute, that it speaks with one voice. So I'm hoping that if it takes a little more time to resolve this, the thing that I'm cautioning everybody is I would hate to have this group recommend something and then have, let's say, folks from the public defender's office sort of work against it when it's before the legislature. Because a lot of times what we'll do, ranking in the chairs, we will just set it aside unless there's a meeting of the minds. So we do that with things with the state's attorney and public defenders. We say, go sit in a room, try to figure this out. But quite often we don't like to be in the middle of something that's not fully fleshed out. And so whatever this council decides to do, I think it has to be a fully baked cake before it gets referred to the legislature. Otherwise, it's probably just going to not go anywhere in any event because it won't be brought to us with one voice from this council. Just wanted to caution everyone.
Thank you, Senator. It is my understanding, though, that most of the members have voted to move it forward. So I hear you on not wanting one particular institution represented to sort of impede the progress of the whole group. So I guess we will move on to the next agenda item. It does sound like the language was voted on, so we're going to keep it in the draft report. I guess it sounds like some people are going to vote against the report and some people are going to vote for the report. And I think that's just the nature of the democratic process. So, Senator Flexer.
Madam Chair, I'm just a little confused. Right now, are we just listening and accepting the reports of the various subcommittees and not actually debating the draft
We were just
of the
listening.
entire report?
Correct. We haven't even gotten to that agenda item. So this just came under the arrest warrant subcommittee.
Right.
Yes.
Thank you.
Okay. Any other questions or concerns for either Joe or Gail? Sorry, Joe, you kind of, no, I know, but we were on offender standards and I know we went back to Gail for a question, so I apologize.
And we finished our 2 items that we've been working on, other than the recommendations, so.
Okay. All right, anything for Joe? Sorry for jumping around. Okay, hearing none. Moving on to the next agenda item is to review and vote on the draft annual report and recommendations. You all got that in your packet. I think it probably makes sense to go through each of the different categories. Not going to necessarily read through all of it, but we'll move from section to section and have discussion based on that. So you have your intro and executive summary, and then obviously from there you have the call of the council, the membership of the council, the process that was undertaken, how many times we met throughout the year, how many times each subcommittee met throughout the year and their focuses, and then you get to the recommendations. So I obviously think that's where we want to spend the majority of our time in this meeting. So I'm just going to go based on how it is in the,
Megan,
yes.
sorry.
Yeah.
I just have a proposal. I mean, it's obvious that there's some of the issues in here that I do have some concerns about. So my thought was that maybe, and I saw that, I think it was a sentencing committee that did this recently, where we could vote to accept the report, and not adopt it, but accept it, and then do a line item vote, say for each one of the topics in the executive summary. There's like 6 topics in there. There's some that I have concerns with, but there's some that I have no problem with. So rather than voting, all at one time, like just because there's one issue that I don't agree with, I would have to vote no for the entire report. I could vote in part because there are some things in here that we worked hard on and I would like to see go forward.
Yeah, I hear you that that's how the Sentencing Commission does it. I think unfortunately that's not how this council's set up, so totally get it. But I think you'll just have to vote based on what you think is best. Yeah. Okay. Yep. So I was just going to start on page 6. Under the first topic is the offender standards recommendations. I just wanted to see if folks had questions or is there any discussion. I'm not seeing anything on Zoom, but anybody in this room? Oh, yep, sorry. Sorry, moving down. Sorry, my apologies, wrong page. It starts on, yes, page 8.
Do you want us to look at all three?
Yeah, so I think we're
Topics?
just focused on the offender standards recommendations. If you have questions, concerns, edits, now would be the time to bring those up and to have a discussion about them. And it can be on all of them, one of them.
Just going to number 3, the supervised diversionary program on page 8 at the bottom. There was a recommendation, A, coordinate in collaboration with the Office of the Chief State's Attorney and the Judicial Branch. I was just thinking that perhaps we could include the Public Defender's Office in that training, as it's our clients who would be affected by this. So if we could include some language that includes our division.
Okay, great. So adding public defenders to that, to item A, correct? 3A?
Yes, 3A, page 8, thank you.
Okay.
If we're gonna do that, I would do CCADV too. I mean, we should have, if it's gonna be like all the different parts of it, it would probably make sense to add victim advocates.
Victim advocates, okay. Okay, so I'm just repeating back so I have it all. So under 3A, we'd add public defenders to the training, victim advocates. Anything else on 3A since we're on it?
Madam Chair, was this idea of adding other entities to this proposal discussed in the subcommittee? And if not, why not?
It's a great question. I would
answer.
defer to the subcommittee. Yep.
I think what we were basically doing is just identifying the entities that would be responsible for actually doing it. I don't think we were meaning to exclude, it was gonna be a very inclusive training. We just wanted to identify the people that were on the hook and responsible for actually doing it.
Okay.
And based on that, it made sense to have the judicial branch and the chief state's attorney's office be the leads to set it up and, you know, make the date, have people come, but it was gonna be very expansive in terms of who was being invited to it. Anyone that's impacted in the court system when these cases come, they were gonna get a fairly good kind of training, informational session about the program, how it includes domestic violence offenders, just in general. So I think it was just going to be a general discussion about supervised diversionary program, but then we would have a discussion about, you know, who goes. And I think that it would be set up by the branch and chief state's attorney's office. We would figure out what the training looked like, the dates, the times, send out the invitations. That was our goal.
So is that?
Madam
you're
Chair.
going to be- I'm sorry, Senator Flexer.
I think that explanation is a reason to leave the language as is.
Yeah, I was just going to clarify. Are you looking to own the training as well with chief state's attorney? Is that what you're suggesting, or are you just suggesting to be trained?
No, I think we should be fully involved, yeah.
Okay. Okay.
I mean, we were going to include people anyway. It was just to, you know, it wasn't like we were excluding people. So either way, whatever gets this wrapped up is fine by me.
Okay. Okay, so then CCADV, the family violence victim advocates, you're just training them, or should they be also involved in?
No, I think
Some of this, I'm
it's
just going to
it's-
say, like, can we make sure we work this stuff out in the subcommittees moving forward?
I think
'Cause-
we did. I mean, I think it was pretty clear that we weren't trying to, you know, we were just saying who would set up the meeting. This wasn't like,
Yeah,
it wasn't that extensive. It was like, we're going to do this thing. There's got to be people responsible for setting it up. And that's who we came up with. It made the most sense at the time. We didn't mean to exclude anybody. It didn't mean that we weren't going to reach out and get input from others about what is the training, what it's about. It was just really administrative and logistical rather than anything else.
yeah, totally understand, Joe. Thank you. Okay, so it sounds like, is everybody okay with adding the public defenders? I don't know if we need to add CCADV to that, to be honest with you.
I was wondering, but there's some inclusive clause in here about a formal training session for all entities within the criminal justice system. So I just feel like perhaps I'm not on a subcommittee, but it was naming two that would be part of putting it together, but it's for all entities. So there's some,
Yeah.
from my perspective, I see something inclusive there with that
Okay.
reference. I want to acknowledge.
Okay. So do we want to keep the language as it, or as is, or add the public defenders? I guess
Why
I'm
don't we
gonna,
just vote?
yeah.
Ma-
Senator Flexer.
Madam Chair, if we have a vote, if you could clarify exactly what we're voting on. And I would recommend that we leave the language as is. It was thoroughly vetted in the subcommittee. It does include all relevant stakeholders. And as you said, this conversation should have happened in that subcommittee.
Okay, so we can make that a motion. Does anybody want to second that? The motion would be to leave the language in 3A, coordinate in collaboration with the Office of the Chief State's Attorney and the Judicial Branch a formal training session for all entities within the criminal justice system on the use of the supervised diversionary program for individuals charged with a family violence crime, as recommended in the draft report. Is there a second?
I second it.
Okay, is there, all in favor?
Madam Chair,
Yes, Senator Kissel.
can I discuss now that the matter's been moved and seconded?
Yes, sorry.
Yeah, I just want to say that with the utmost respect to my friend and colleague, Senator Flexer, I disagree. I hear the Public Defender's Division wants to be included specifically. I think Attorney Pelka is spot on that there's inclusive language. It's sort of broad. So I think that one could argue very well that they're already included. They're just not named. But I think just to sort of like have peace and harmony reign, I don't see any downside by listing them as well. And so, on this motion, I'm going to vote no, because I think that I don't see any reason why we have to be stuck with exactly the same language that the subcommittee voted out when we know that the language could be read broadly and the Division of Public Defender Services want to be named. And I think that that's just a nice thing to do. I don't think that there's any downside to it. So I just wanted to put that out there. That's all.
Okay. Thank you, Senator. Any other discussion before we vote?
If I just may follow up, just briefly, the Public Defender's Office is the only defense-oriented organization on the entire committee. So I think that's part of the reason we want to be included. We are the only representatives for our clients out there. So it is important to us and to our clients, and I think to fairness in the judicial system to include us. Thank you.
Megan, can I weigh in here?
Sure.
It would seem to me that if we're going to start adding these entities, that certainly CCADV or some entity on behalf of victims, survivors should also be designated. I agree with the language as it is because it is pretty comprehensive. But if we're going to start adding entities, I think they all have to be added.
Okay, thank you, Nancy. Any other discussion before we vote?
Ma'am,
Yes, Chief Fox.
perhaps a compromise might be to simply eliminate who it's going to be in collaboration with. Coordinate a formal training session for all entities within the criminal justice system. I now realize that you're going back and trying to modify what the subcommittee
know.
created, but
Yeah.
it seems like, I don't mean to minimize anyone's concerns here, but it seems a relatively, as Senator Kissel mentioned, innocuous change that may satiate these concerns with no real impact to the language, the substance of the language.
Honestly, it doesn't matter. We have to do a training. We'll figure it out.
Okay.
I'm going to include everybody. Gail's going to set it up and have lunch for us. And I think that it is what it is. I mean, I don't.
Okay. Well, so what we
We're
can do
spending a lot of
is, so
time
we had one from Senator Flexer, right? So I got to honor that first initial suggestion as a motion. We're going to vote on it. It may pass, it may fail, and we can then always entertain adding the public defenders to it as the next, and have it pass or fail. Does that sound okay? Okay.
Madam Chair?
Yes, yes, Senator.
Yeah, I just wanted, I agree with Chief Fox. I think it's a brilliant compromise by not naming anyone per se. No one can feel like their toes were stepped on inadvertently. And that's why I'll be voting no now. And then hopefully if it doesn't, and I'm not rooting against it, but if it doesn't pass in its current form, I think that's a wonderful compromise going forward. Thank you.
Okay, great. Okay. All right, any other discussion before we take a vote on the motion that's on the table? That was seconded by Gail, I believe. Yes. Okay, all in favor of keeping the language as is under 3A in the draft report, please signify by saying aye and just raise your hand either on Zoom or in the
Aye.
LOB. Okay, so I have Senator Flexer as an aye. I have Phyllis DeCara as an aye. I have Ginger Wilk as an aye. Danielle Sanko Dolce, sorry if I messed up your last name, I'm sorry. Shauna Harrington, Andrea, and did I miss anybody online? And then did you get everybody in the, yes, okay. All right, all opposed. Okay, I have Attorney Canning, I have Chief Fox, Karen O'Connor. Hold on, I'm going to Zoom. Nancy Tyler. I don't have anybody else with their hand up, so I
Oh,
apologize.
my hand's up. My hand's a
Oh,
no.
okay. Yep, I see Senator Kissel, Captain Maynard. Judge Doyle, I don't see a hand up. I don't have anything from Judge Doyle or the Department of Corrections. Okay, so that would leave just any abstentions.
Megan, I had my hand up before. Sorry
Oh,
if you didn't see me.
Oh, I apologize. For the ayes or the opposed?
For the ayes.
Okay, sorry about that, Judge.
No problem.
Okay, and then just Department of Corrections. Okay. I don't have an aye or opposed or an abstention for Department of Corrections. Okay, all right. That leaves us with what? Okay, all right. So I believe the motion passes. All right, moving on. Anything else on the offender standards recommendations? Senator Flexer, I don't know if your hand is up as a question under offender standards or if it's just still up from the voting.
It is, and I was going to ask this during the subcommittee report too. Can someone from the subcommittee explain the language in on page 9 in section B, a non-legislative working group?
Joe, you want to take it, or Merritt?
Yeah. So based on our November meeting and our further discussion on the supervised diversionary program, we realized that after hearing from the state's attorney, the assistant state's attorney in New London, that this is actually happening already, that judges are ordering the program and ordering DV intervention as a condition. And it's on a case-by-case basis, which I think we all agreed was the best way to handle that. So in light of that new information, we thought it was best at this point then to form a small, non-legislative working group of the individuals involved to explore or dive into its usage a little bit deeper to find out, because we only know what New London's doing. because we're not even convinced at this point we need a legislative fix, because it's already happening. And so we'd like to learn more about what is happening. I know that Johanna had expressed some concerns to the subcommittee regarding what if a person is not able to complete the DV intervention, then what happens? So I think there are some real big legitimate questions here on a statutory change, and I think we need to understand what is happening in the courts before we make any suggestions for legislative change. So that's where the
Okay, any,
Madam Chair, the audio cut out at the end of those comments.
Okay, sorry about that.
It's not your
Yeah,
fault.
that was we modeled our language after the arrest warrant subcommittee to create the non-legislative working group, so that it could be done just from the subcommittee, so that's where that came from.
okay, any other?
But will that exclude members of this council attending the subcommittee who are legislators?
Oh, no, that was not our intent at all. It was just to be able to gather more information and get the people to the table that had that information, because it wasn't until we heard from the Assistant State's Attorney in New London that we knew this was already happening. And so looking at this from that view, I think we need to take a deeper dive.
And I think we saw that, we saw the recommendations from the arrest warrants and orders for protection, and that's the language they used for the work group, so we just thought that was going to be the acceptable way to phrase that. It wasn't meant to exclude anybody.
I appreciate that, but that's definitely how I read it.
Okay, we can change that. I mean, it was not intended,
Yeah.
it was meant to be a non-legislatively created working group. So not intending on excluding legislators, if that makes sense.
Right. I mean,
I think maybe we can just take out non-legislative because, yeah. So it sounds like.
Yeah, just a small working group then. Or a working group.
Yeah, maybe the recommendation can be Senator Flexer that it's just a working group.
that sounds great.
Okay,
Thank
so,
you.
okay, so we will change the language under both the offender standards, 3B, to just say a working group, and then under the arrest warrants, under item 1 for them, a working group. Does everybody follow me on page 8 and 9? Okay, so I will make a motion to update that language to a working group for both 3B under the offender standards recommendations, and then under item 1 for arrest warrants and orders of protection. Do I have a second? Great, all in favor? Or any discussion, sorry. Okay, great, all in favor? Aye. I think I have all eyes on Zoom as well. Great, okay. All right. Okay, anything else under offender standards? Any questions, concerns? Okay. All right, moving on to Police Response to Crimes of Family Violence Model Policy Subcommittee. I have a feeling this one might go a little smoother, Chief Fox. So the floor is yours if there are any questions, comments, edits.
Thank you, and here's the brief summary. I'll certainly be more than happy to explore in further detail as folks should wish, if there are any follow-up questions. The first two that you see under our section, both referencing page 7, were the changes to the utilization of the LAP protocols. As you know, the LAP protocols were being routinely followed in Connecticut. However, it was not mandatory under the policy. So we were in a situation, and I certainly have the greatest of confidence in my contemporaries, but we wanted to remove, frankly, the element of discretion and assure that LAP became a mandate as we know it is a best practice. Page 9, as soon as possible, was simply an effort to send the message that the execution of arrest warrants, we can't set a standard that's going to be within 24 hours because in a given 48 hours, because in a given case, 24 hours may be way too late. 5 hours, 2 hours may be way too late when the arrest warrant is received. So but similarly, there may be instances where it may be understandable that an arrest warrant execution just simply is not possible until some later point. So the language as soon as possible was the change under page 9. The arrest warrant and notification procedures, that's page 12 and 13. Same sort of general logic there. Page 16 and 17 was an unfortunate event that had occurred in Connecticut, southern part of the state, that caused us to realize that perhaps the language as to a police chief and who the notifications would go to in the event that he or she, a police chief, was a subject of a domestic violence case, that the language there was not as robust as it needed to be, because within the police world, the police chief doesn't have a boss, but certainly within municipal government, a police leader, municipal government or state government, a police chief certainly does have a boss. So that was the changes under 16 and 17. And then the protocols for investigation of weapons, page 22, was once again, 22 and 23 actually both collectively. Those were both practices that were extraordinarily clear 20 years ago under what I recall to be an MOU between the state's attorney's office signed off on it, the Chiefs of Police Association signed off on it, and the then commissioner at the time signed off on it. But as we know often happens when matters are, does anybody have a copy of that MOU from years ago? And it doesn't reach a more formal invested in a document that's living and breathing. Some of those protocols may have slipped in the law enforcement world, much to our dismay. So you see the memorialization of those protocols, page 22 and 23. Finally, to the extent that it's helpful, I believe that all of these were individually explained in an earlier meeting and received group support.
Yep.
Now we're simply reiterating them for you as part of this process as well. Thank you.
Great, thank you. Any questions or comments on those recommendations? I guess just a point of personal privilege. I do want to thank Chief Fox and Captain Maynard and Karen specifically because they did an amazing job to get the LAP program included in the post standards, and that actually has not just impacted Connecticut, but I'm sure you saw Chief Fox and Iowa reached out to get more information. So it's actually having an impact across the country too. So other states are reaching out based on that. I think it was Council Bluffs, Iowa, that reached out initially, and we've had some other outreach from other states. So I just want to give them, if we can, just a round of applause for all the hard work that they did on that. Okay. Next on the list is arrest warrants and orders of protection. I know we obviously we tackled the language in item 1, but if there's other questions on item 1, can certainly entertain those questions or comments or edits now as well. Okay, I'm not seeing any on Zoom either, so apologies if I'm not seeing your hand, but I don't see any on Zoom. So seeing none on item 1, moving to item 2, which I think we briefly chatted about earlier in the meeting. Yes, Merritt.
Yeah, I know there's a note on the bottom, so I'm just hoping that we can include standing criminal protective order in that language when it's being considered by the liaisons, because I think without it, it doesn't make sense. So, thanks.
Good suggestion. Thank you.
And I would just like to reiterate my objections to this language, both because it excludes defense counsel having the opportunity to have that information. I think that should be included. There should be language saying that that is not applicable to defense counsel and his or her legal team. But more importantly, I object to this language altogether because I do think it is a constitutional issue. I think there is no notice here to the defendant about how he or she is to avoid arrest and felony conviction under this language when they don't have the information in front of them.
Okay. Any other comments or suggestions on item 1 or item 2 under arrest warrants?
Oh, raise my hand, okay.
Yes.
I would just like to address Joanna Canning for a second. That problem comes up routinely when someone, during the course of a standing protective order, might inadvertently run into somebody. I say routinely, it doesn't happen often, but it can, because standing orders can last up to 60 years, and people can move multiple times. And so there's no way for the system to know where somebody goes in the future. The obligation is to, if you see that person, is to then leave. And then the police can then do their investigation as to whether that was actually intentional or not. I mean, that will come through the process and be vetted out at some point.
And I think that's a problem. And to have somebody have to come through the process, that means an arrest and possible detention while they're waiting for this to work itself out for what could potentially be an innocent mistake or even just no notice. So I think it's a problem in the way it exists now that you demonstrated, and I think it's a problem here.
Well, there's a couple problems there. One, if it goes through the process, then it may not end up in, if it shouldn't, then hopefully it wouldn't end up in an arrest. The second thing is I think the victims need a peace of mind that their abuser does not know where they live. At what point do they get that onto your system?
Oftentimes, even if the victim is moving, they're staying within the same community. If the defendant, whether the defendant accidentally stumbles on them or knows where they live, I don't see the peace of mind that the victim is getting in either one of those situations. They're out. The victim is out there exposed, never knowing when a defendant may stumble upon them because the defendant doesn't know where they are, doesn't know how to stay away because they haven't been given the information.
The order is then to leave when they see that victim.
Sure, always is.
Thank you for that. Any other questions or comments? Okay. All right. Okay. So we've made some edits. We voted on them. Now comes the time to vote on the full draft report as amended. So I will make a motion to accept the 2025 council report as amended. Any second?
Second.
Senator Flexer. Senator Flexer, do you have a question or?
Oh, I was just trying to second.
Okay, great. Thank you. Any
And-
discussion?
Madam Chair?
Kissel.
Yes.
Yes,
So-
Senator Kissel.
Thank you, Madam Chair. So I've listened intently to all the discussion, and it's great to have so many intelligent, hardworking folks on this council. And I, once upon a time, was a special public defender, so I guess I'm a little sympathetic to that perspective. And I think some of those questions are important and may need further investigation down the road. But for purposes of this afternoon's vote on this total package, I think there's just too many pluses to have any of the concerns raised undermine my support for this as a whole going forward. And so while I acknowledge that I do share some of the concerns expressed this afternoon, I will be happy and proud to vote yes to move this forward through the process. Thank you, Madam Chair.
Thank you, Senator. Any other questions, comments, discussion? I will just also just add to that too. I do think there's an opportunity to work some of those details out in that legislative liaison group. So I think what you see here today is the draft, but as we all know from last year, the draft can evolve, and I think the goal is to have the legislative liaisons come to the table and really work on that together this session. So my only other comment is to thank all of you for your time and your efforts, because I know you're not getting extra time to do this or extra pay to do it. So I really do appreciate all the different perspectives and points of view, all of the efforts that you've all made over the last year to make this a really successful and strong draft report. So thank you. And I hope we make it out of here to see Santa downstairs. So, okay. So
I'm
any
missing
other
Santa.
yeah, questions or comments?
I just
Gail?
have
Yeah.
one more order of business. We've been talking about the Assistant State's Attorney from New London, or GA10. That's Sarah Steer. And Sarah Steer is going to step into my role as the co-chair of arrest warrants and orders of protection. And just to give you a little bit of information about Attorney Steer, again, she's from GA10. She's been working for the Division of Criminal Justice since 1996. She's handled the domestic violence docket in that court from 2013 until 2021. And as we know, the DV cases constitute approximately 1/3 of our criminal cases. She facilitates a weekly team meeting with family relations, the victims advocates, Office of Adult Probation, as well as DCF. She's also participated in some training with law enforcement in that area, as well as conducting training for dispatchers. And she is well suited for this subcommittee as well as this group. I will stay on as the Chief State's Attorney's designee. However, Attorney Steer will be the co-chair of the subcommittee.
Thank you.
That's amazing. Congratulations. We're so excited to have you. I'm sure you're very excited to be here. No, it's going to be great. We're very excited to have you. Thank you very much, Gail. Any other questions, comments, discussion before we take our vote? Okay. I'm not seeing any on Zoom. I'm not seeing any here. So, so all in favor of the draft report as amended, please signify by saying aye.
Aye.
Aye. Okay, hold on. I'm just trying to get everybody on Zoom. I've got Senator Kissel, Senator Flexer. I've got Ms. Garcia, Phyllis, Ginger, Judge Doyle, Danielle, Andrea, Captain Maynard, Nancy Tyler, Shauna. Okay, I think I have everybody on Zoom, and then everybody here. And those opposed? I know. It's okay.
I'm not going to oppose because there's a lot in here that I do agree with, but I will abstain for the reasons we discussed earlier. That's all.
All right, thank you. Okay, 1 abstention, 0 opposed. Thank you. Okay. All right. So the next item on the agenda is other business. So there's just a couple things on their other business. First, I just want to introduce, CCADV has a new policy manager. We're trying to build our policy team. And so we're very excited that Mario Volpe joined the team a couple weeks ago. We actually took him from this building. So you probably are familiar with him to a certain extent, but he is working with CCADV now. So we're super excited to have him. And The other points of business are just, we need to set the new meeting schedule for 2026 of the full council. And Sarah, you actually took one of the other business agenda items off. We obviously needed new co-chairs for our combined groups. So Sarah is one of them. We need one more. So if anybody wants to volunteer in the 2026 rendition of this, please reach out to Liza or Mario to set that up. So yeah. Okay. All in favor of Merritt as the other co-chair of the court ops, well, I'm calling it the court subcommittee. Okay, hold on. Yeah.
Mario will reach out to every council member individually next month, just to reconfirm which subcommittees you sit on. You can sit on both, you can sit on one or the other, just to reconfirm so we make sure we have a current updated list of subcommittees.
Okay. All right, well, it does sound like Merritt and Sarah will be leading the new group, which is exciting. So thank you all for that. Okay, so now just getting to the full council meetings for the 2026 year. I think this schedule has seemed pretty good for people that we're meeting on this cadence. So looking to see what folks' schedules are in the end of January, end of February timeframe, and then we can set the schedules from there. It would still be Wednesdays at 12:30. And if this cadence works, we can just send it out to everybody. Does anybody have any conflicts like immediately at the end of January or February? Just so we know for setting the schedule.
Monthly, that's fine.
Okay.
I'm good with that.
So January would be, hold on 1 second. Sorry. So we usually do the third Wednesday, so it would be the 21st.
The 21st would be an issue for me.
Okay.
I have court that day.
Okay. Okay, so do we want to move it to start in February? Or oh, right. Yeah. Does the 28th work for most people then, if we just move it back 1 week? 28th, January 28th? I'm looking on Zoom too. Hold on, sorry. It looks like most people can do the 28th on Zoom. I'm getting thumbs up. Okay, so we'll set the date for January 28th, and then we'll set the rest of the calendar from there. Does that sound okay? Okay, great. All right, anybody have any other business that they want to bring before the council? Okay, then the last thing is just to adjourn the meeting. Before we go, I just want to wish everybody a very happy holiday and a hopefully healthy new year. Really, really appreciate all of your time and efforts. I hope you get to spend a lot of time with your family, relax, eat some good food. Hopefully you get everything you want this holiday season. And if you're me, I'll see you at the hockey rink. If not, I will probably not see you. So, all right. So with that, I'll just take a motion to adjourn.
So moved.
Great. Second?
Second.
All right. All in favor?
Aye.
Awesome. Have a great holiday. Happy New Year.
Christmas,
Thank
everybody.
you.
Merry Christmas.
Thanks.
Happy New Year.
Bye.
Merry Christmas.